Hey everybody, you got Eric here, and Steve's taking a little bit of a holiday here. If you live in Europe, I believe that's how they say it. And instead of Steve today, we got Don Krupens with us. And Don, I just want to say hello and invite you to the podcast here. Thanks for joining us.
Oh, thank you for having me, Eric. I appreciate it.
So normally when we do these Rent Prep Court episodes, we build out the episode, then I'll share it with Steve and we'll listen to it and we'll kind of discuss. But this week was actually a little bit differently. Don and I are talking first when we're talking about wear and tear and things that happen in the rental property, specifically in the state of California for this episode. But I wanted to actually talk to Don first and kind of get some ideas from him on what you can and can't do, so then I can actually make the episode make sense. Because I was a little bit nervous that I was going to put something together and Don's like, no, that's completely inaccurate.
Well, and that's often how the law works. You know, people put together a situation and the law has to go unscramble it. So
yeah.
I think it's a perfect approach here.
So, Don, thanks again for being on the show here. And one of the things that I'm really excited to get you, kind of pick your brain about is wear and tear. And we were talking before we got on air here that wear and tear is kind of a frustrating subject to, I think, landlords and tenants, because it is one of those things that you're saying is a little nebulous. It's got that gray area in the middle that you're not really sure how it works. And I kind of want to run down some bullet points here that I just wanted to get your opinion on. So,
Sure.
First thing, so let's say in a particular instance, we just have a regular tenant-landlord situation and the tenant leaves and there's little scuff marks on the walls. The tenant doesn't have a disability or anything. What would you mark that up to?
Right. So I think it would be appropriate to go ahead and let's, to the extent we can, define wear and tear. And then what we'll do is we'll then, kind of take that definition as concrete as we can make it, and then we'll apply the facts to it. So as you mentioned just a bit ago, Eric, this is a term of art. It's something that the courts have, and then this is across all jurisdictions, not just California, have been really reluctant to define. And as Eric mentioned, we were talking off air before, and it's kind of like asking 10 people if it's hot out. You're going to get 10 different answers and 10 different perceptions of what the temperature feels like to them. So wear and tear is to some degree going to be in the eye of the beholder. But to the extent that the courts have really tried to define what it is, I know there's a very old New York case. There's a more recent Washington, D.C. case. And what the courts have said in those situations is things that occur in the ordinary course of the living are considered wear and tear, and consequently, a landlord cannot deduct those items from a security deposit.
Okay.
So with kind of that framework in mind, if we talk about scuffs on the wall, for any of us who's ever lived in a dwelling, scuffs happen. You're carrying a luggage or moving furniture or carrying groceries, or you're carrying a child. Face plates where you turn the lights on and off, and we have dirty fingers. Those things occur. So I think almost universally I can say adamantly in California that those things would be considered kind of normal wear and tear, in which case the landlord would be prohibited from deducting costs to remediate from the security deposit.
Okay. And then let's say if the person, let's see if I phrase this correctly. If you have somebody normal wear and tear, so a scuff mark, right? It's just very sporadic, just throughout the house, something that looks normal. They lived there for a couple of years. But let's say that person was wheelchair bound. How does that change the scenario? Does that change it at all with wear and tear and what's considered that?
So the way the law would treat that situation is if we go back to our definition, which was those things that occur in the normal course of living, a disabled person or a wheelchair-bound person, their mobility and the devices that they use to possibly assist them are different than what you and I might usually use. So scuff marks or door dings or the frame around a door if it gets damaged from a wheelchair. Because that's how that person interacts with that environment, and those are just kind of some of the general risks of interacting in that environment. Those things would be considered normal wear and tear.
Okay. So let's take that another step further. And this is actually a great question that we got from the Rent Prep for Landlords Facebook group that came from Susan Fox, who was asking specifically about kids, grandkids, and their guests. Because, she said they can leave tracks, scratches, scrapes on the walls, doors, floors, from pushing toys, dropping toys, running into cabinets, especially the grandkids and guests, she said. So what would you say, piggybacking on your last thought there, if it applies to children and the damages that they're doing?
Sure. Again, I think the way that the law would treat it is they would not expect a household with children to stay as pristine as a household with children. And one of the ways that we can draw a distinction between just wear and tear and a damage, which is something that the security deposit could be withheld for, is kind of the nature of the incident. Okay. The court sometimes describes damage, and again, that's something that a security deposit can be withheld for, is something that happens abruptly. A baseball through a window. You spill paint on carpet, or you drop a hot oil on a linoleum floor and it makes the linoleum buckle. Okay. Those are acute, one-time, significant damage incidents, which would be distinguished from something that just happens over time. Like we said earlier, fingerprints on the wall. I think the same logic would be applied to children. So if you have a child that likes to run his hands down the wall when he walks down the hall, or goes around flipping on and off the light switches, probably more along the lines of wear and tear. Yet if you have a child who likes to draw on the wall with an ink pen or a crayon, or takes a toy truck and likes to smash it into the wall, I think that would certainly be considered a damage for which deductions could be made from the security deposit.
Okay, that makes a lot of sense. Before we got on the air, we were talking about a specific question of broken drywall. So in this particular case, let's say that this was created from a door that had been repeatedly being opened and hitting the wall, and then after a while it kind of created the hole in the wall. How would that apply based on the definition you're just giving between, what I'm guessing is it's something that's happening over time, but it's not as acute. So does that mean it's wear and tear, or how does that work? Because there's some negligence involved too, right?
Yeah, absolutely. And I think that's what we have to look at. And that's, when we start looking at the definition of wear and tear versus damage, you just hit on really the word that draws the distinction, which is negligence. The problem is that that term is not any more well defined in the law than wear and tear is. Sure. So you could imagine a situation, and we've all been there, where there wasn't an appropriate door stop, and you open the door once and it makes a little dent in the drywall. And then if you open it again, it makes a little bit bigger dent. And, by time 3 or 4, you're noticing a pretty defined mark. What I believe most reasonable judges would do in that case would say is, well, after once, maybe yes. Twice, maybe you forgot the first time. But now this is 3 or 4 or 5 times, or even gone so far as to put a hole in the wall. You as a tenant didn't act reasonable to mitigate that risk, put a tennis ball behind the door, call the landlord and say, hey, I know it's only 99 cents. I see that there's no door stop here. I would love it if you came over and put one in, something along those lines. So, yes, it doesn't meet the definition of really an acute damage, but there's a component of negligence in there where some minimal steps by the tenant rather could have prohibited the damage.
Okay. Going in a little bit further with this, back to the Facebook group, I'm going to kind of work through some questions here that I think we got some great ones. We just want to make sure that we cover everyone who asked some questions here. Andrew Schultz said some common questions he gets is repainting after each tenant. Do pets impact what you can and can't charge wear and tear? And how do you determine if it is wear or tear damage? So I think we answered that last one. As far as do you need to repaint after each tenant, what are your thoughts on that?
From a purely legal standpoint, no, I don't think there's any obligation to. If the question really is, if I repaint, can I deduct it from the security deposit? again, I think it kind of goes back to our earlier conversation.
Yeah.
If the and I use the word damage loosely, if the reason for you repainting is normal wear and tear, then no, you're not going to be able to deduct. If there's crayon on the wall, or there's ink, or there was wallpaper that was torn off that you need to repaint, or you need to re-wallpaper, for that matter, then I think it would be considered a damage for which you could deduct from the security deposit.
Okay. And then as far as pets and how they impact, can you charge or can't charge wear and tear? How does that work?
Pets are interesting. It would be my argument, and I think most of the cases, at least that I'm familiar with in California, play out this way. You do not have to relinquish your home to a pet owner and accept that the pet is going to do some extraordinary amount of damage, just as a virtue of having pets in the home.
Okay.
So, you would expect that that pet owners would, pick up the hair, potty train their animal, make an outdoor space available for the animal to go to the bathroom, or if there's an indoor space, appropriately protect the space with new papers and pads and things like that.
Yep.
I think anything beyond that, so chewing on the molding, scratching on the front door from jumping up, certainly urination or defecation on the carpet, or stains related thereto, all of which I would argue that while pets are a normal part of that household, I would argue that none of those are behaviors that a landlord needs to accept as a pet being in that household. Then consequently, I would consider those damages.
Okay. And as far as the process, so let's say a landlord is going through this, somebody's moved out, they've decided what they believe is wear and tear and what's damages, and they let the tenant know, we're deducting X out of your security deposit. The tenant at that point says, I don't think that's right, and starts arguing with the landlord. Where does it usually go from there? What have you found?
Yeah. It's a mixed bag. So to some degree, it depends on the monetary amount we're talking here. And the other factor that I often see that landlord and tenants start squabbling about are particularly long-term tenants. So someone's been in there 5 or 8 years. I just know in my household with 2 children, a wife and a dog, after 8 years of probably limited maintenance, if I were a tenant, what the house might look like. But again, it's still, in normal circumstances, it's still wear and tear. The landlord at the end of that 8-year tenancy may want to repaint, recarpet, refloor, any number of things, redrape. But that would be a choice, not necessarily a cost that would need to be borne by the tenant. So those are a couple factors that I see, and it determines which way things go.
So you're saying if a judge, if it goes to court, small claims, and a judge is sitting there, it's going to be potentially a different outcome if you're talking about somebody who's there for a year versus 9 years, because the definition of what is wear and tear is going to be different from somebody who's there for 12 months compared to 9 years.
Yep. Yeah, absolutely. Okay. So that's definitely one of the factors as a landlord I would consider on how much I fought this issue. The other thing too, you have to consider the cost of litigating. And, in California, you can't have attorneys in small claims court. So you eliminate that cost. And while the filing fees aren't very great, there's still a time component. So if you're going to be out, $500, in my opinion, it's probably not worth it.
Okay.
If it starts getting above 500, then, you might want to start considering possibly taking it to the next step. The last thing to consider, and Eric, you and I in a previous episode had talked about this, is the person going to show up? If they do show up, do they have gainful employment? Can you find their employer? So even if you get a judgment, can you collect? If they've been a spotty tenant, collecting rent has always been a problem. They're kind of transient in work. Then maybe that $500 looks like a bargain, considering what you might have to pay to collect, even if you got a judgment.
Yeah. Okay. I think that's all helpful information. If you're, sitting in that position of, is the juice worth the squeeze? They say, right? I
Yep,
know
exactly.
Steve here at Rent Prep's always saying that to us. So
Yeah.
another,
And
yeah, go ahead.
if I could interrupt and just back up just a little bit, you know, uh, preparation in anticipation of renting the place, and establishing the condition of the premises at the time that it's leased is critical to the outcome. It won't define the outcome, but it can surely tip the scales one way or another. So if you're going to repaint, for example, and it's your policy to repaint between each tenancy, um, document the painting. Keep your receipts. If you have a company that does it for you, make sure you hold on to that information. Take pictures, thorough pictures, maybe video document it. And of course, in the move-in inspection, you want to be thorough in making sure that the tenant, denotes anything that they believe is not up to snuff. So it even starts, to me, it starts long before the lease is even signed.
Yeah. Maybe this is a bad analogy, but I like giving bad analogies. But I feel like you almost have to kind of approach it like the judge is a robot, and you just have to feed him facts to get the judgment that you want. You're not going to be able to go in there and just be like, no, you got to believe me that this was this. Like he needs to see facts so that he can make a ruling that favors for the landlord or the tenant, whoever is going to the judge.
Absolutely.
So if you can just think of him as a robot, feed the robot facts.
You got it.
Working down the list here, and I know we're going to wrap up here in a little bit, but Becky here in the Facebook group, I thought she asked a great question. So she's talking about with wear and tear, are we allowed to deduct if we DIY versus hire it out? So what she's saying is if she wants to DIY, do it herself, the repairs, does that matter? So in the state of California, what would you say for this?
So in California, a homeowner is authorized to go ahead and make the repairs themselves. And the way you value those repairs is what it would be commensurate with somebody else performing the services for you. So if you have somebody that's going to come, and let's say you have to, the place is a mess and you just need a deep clean, but you're feeling, overzealous and you want to get some frustration out because of the tenant, and you decide to tackle it yourself. If a cleaning crew is going to charge you $20 or $30 an hour, and you spend 10 hours, then you can go ahead and value your labor for that effort commensurate with, and you're somewhere in the $200 to $300 range.
Sure. But if you are a corporate CEO who values his time at $300 an hour, you cannot say, well, I was there for 10 hours, that's $3,000. It's got to be based on the work that somebody would have been doing.
Yep, exactly. So the judge is going to say it's going to be really just kind of a smell test. Does this sound reasonable? If I had to clean up a 2,000 square foot house, maybe it takes me 6 or 8 hours to do a deep clean. You want to charge $200 or $300? Sounds reasonable to me.
Yeah. And I think that one, of course, like we say this all the time, but it goes back to whatever your local law says as well. I could be wrong on this because I was discussing with Andrew Schultz before, actually, and he thought that in New York State, it was the case that you could not DIY. I'll look that up and I'll put it in the show notes, what I can find on that. But check out your local state, check out your local laws, because you may find that it's different where you live and you can't do DIY work and deduct it, or you can. So always worth a look. And the last thing here, Don, I wanted to actually pitch you a little bit here, a little advertising for yourself. But I know that you do a pretty cool program. So if anybody's listening and they're in California, you have a service that's real affordable, and it's like a monthly program, a retainer that you can have you or somebody in your law firm at LawVex on. Can you tell me about that in a little bit more detail, how that works?
Sure, you're absolutely. And, one of my legal obligations is to disclaim this forthcoming advertisement. So this is an advertisement for legal services. There we go. So
I'm not getting paid for this advertisement, though.
Yeah.
You're paying
and I'm not getting paid for this podcast either. So thank you. I appreciate the introduction. LawVex has a program, and we're really proud of this program. And it all originated some years ago, where we just felt that there was a lack of really rapid response legal services for folks. So the managing partner of the firm that I'm with, he developed a program. It's a subscription program, and it's $49.95 a month, so it works out to be about $600 a year. What that does is it gives you an opportunity to speak with me 4 times throughout the year to discuss any legal issues that you have. Those are designed to be relatively short, 15, 20, 25-minute conversations. If further work is needed, we can do document review and things like that, and that would fall under kind of a different fee schedule. If you are a business, if you're incorporated in California, that fee also includes all of your annual state filings, which is a nice benefit. It's really designed to be hands-off for you in terms of that component. And, it's really just somebody in your corner. If something comes up, you have quick access to me. Our goal is to respond to our team members within 24 hours and make sure we can address the issues they have.
I think that's such a key piece of that too, because I think I actually tagged you because you're in the Facebook group as well, and I tagged you on somebody who I think they were in California. I hope they were.
Right.
But it came up, and she was having an issue that she was having trouble getting communication with her attorney with, and she just something she needed, fixed like immediately, and she just kind of felt like she was just floating out there in the middle of the ocean, kind of thing. So I think it's worth it for somebody if they're in California to check this out, because you can have that peace of mind and just have somebody that you can call, especially if you just got a few nagging things that are kind of, lying out there that you want to just kind of get some professional opinion on. So.
Excellent. Well, thank you, Eric. I appreciate the opportunity to talk about that.
Yeah, absolutely. And if you want to check out more about Don and LawVex, you can go to our show notes. You can go to rentprep.com, and in the header, you'll see a link for the podcast, and just look for the latest podcast here. And I'll be also linking out to some resources that Don and I have done together in the past. We'll have a playlist of videos that you can check out on a bunch of various topics, so you might find some help on those as well. So, Don, just want to say thank you for your time again.
Thank you.
Appreciate, a professional's opinion on Rent Prep Court and what's going on here.
Well, you do the best you can. With these topics, it's fuzzy, folks, and there's no way of getting around it. Reach out to your professionals, reach out to the group. There's great information out there, and document.
Yeah, always goes back to that.
Yep.
All right. Thanks, Don. Appreciate it.
Thank you, Eric.